Okay, good morning. I'm Phil Boedeker, as was mentioned. I recognize many of you in the audience. Thank you for being here. Those I don't recognize, hopefully I'll get to work with you one day when you get tired of your current attorney. No, I'm kidding. So I'm going to be talking about eminent domain, and in essence, the question that we always get and will continue to get, and I'm sure you've asked if you've been a part of eminent domain, is it ours yet? Right? You know that there's a project, you need that roadway expansion, that underground utility line, that lift station, etc. And you're like, Phil, just go get it for me. Tell me when it's mine because I have a contractor on standby ready to dig. Right? So that's usually the state we get it in, and which is fine. We can handle that. Lauren can handle that, and I'll just back him up, actually. So again, this is an overview. 20 minutes is not enough time to study the history of eminent domain and to go through all the process and procedure and the intricate timeline that's involved, both statutory and just reality. But in the next 20 minutes, we'll touch on a lot of points. But really, my main point of this discussion with eminent domain, give you kind of a checklist, give you kind of a timeline, but really the outcome is what I want, is what when I gave my last Texas Open Meetings Act and Texas Public Information Act and ethics training at one of my cities to one of their boards. And afterwards I was told, hey, you really scared them. I don't think they're going to talk to each other even at social events. To which I responded, good. Right? So what I want to do is I want to scare you to the point where you go, ooh, we need some land. Let's talk to our attorneys first. Right? Like that's where I want us to get. So with that in mind, let's get into eminent domain. And I can tell you all about that, who I scared straight later. Okay, first off, I guess I didn't realize it built. I should have previewed this. Perfect. So the boring stuff, and by boring I say the statutory stuff, right? So this is the authority where eminent domain comes from. Constitutionally based, statutorily based, right? These are the rules that sort of shaped some timelines are built by this, and some procedural steps are built by this. So this is where that comes from. So if you need some light reading during the next break out the Constitution, flip through that. It's pretty big. It's there. Government code, pretty long. You can read a couple of those. Obviously, there's over 2,200 chapters in the government code. So if you haven't read that, it's a pretty good read. But that's where those are found. You let me worry about that. Oops, did that? Yeah, perfect. Nope. See, they don't all build. See, you need to check your slides, all right, before you give presentations. There's my tidbit. So eminent domain, before the proceeding begins, this is your why, right? Obviously, you're stepping into this situation needing land for something, right? It's not just a good idea. It's not just a golf course. It's not just fun to have, right? You need to know why. Obviously, it's going to be something, like a lift station or a new water well, or a underground utility line, or TxDOT's coming through and expanding the road, so you have to move your property or your line out of their right of way into your own right of way, and it's just all these trickle down effects when other government entities get into play, right? So that's really the why of this, your authority. So yes, if you're a city or certain other eminent domain entities. I'm mostly speaking to cities here, just in general, but there are some other authorities that have eminent domain power. But for cities, for the most part, you have the authority. So double check, do I have the authority? Yes, you do. Congratulations. And then do we need it? Is it a valid public purpose, right? Is this for fun because it'd just be a cool idea to have a new pocket park over here, or is it a truly valid public purpose? That's the analysis that needs to be done. And obviously, there's some things going on behind this as well, right? You don't just decide, hey, we need to move a water line. Let's, I guess we need this much space, right? No, there's some analysis, there's some engineering involved, right? There's some surveying involved, things like that. And we'll talk through a lot of those situations. But this is it. Do you need a new fire station? Do you need to expand the fire station? Do you need to expand City Hall? Do you need to relocate City Hall? Those are the type of questions that come into play when, hey, do we need this? Is this for our own, some individual private benefit, or is this a true public purpose? So again, these are all things you're deciding before we're truly proceeding into eminent domain, right? And again, think this whole time, timeline. right? And that's the point here. The time that eminent domain takes is always going to be longer than you want and longer than you think. It's just the nature of the beast. So you got to start with good faith negotiations, right? You have to give this bona fide offer to the landowner. You have to, right? It's this initial offer. So what does the initial offer include? It's a bona fide offer based on appraised value. So what do you need? You need an appraisal, right? We'll talk about that in a moment. All the things you need in order to get to an appraisal, right? You have to include the summary, at least the summary of the appraisal. Oftentimes, if it's coming through our office, we'll just include the whole appraisal. No reason not to, right? Here you go. This is why we think it's worth what it's worth. An instrument of conveyance. So, hey, if they want to just go ahead and accept the offer and sign that deed and get it back to you, fantastic, job done. And then the landowner's bill of rights. Now, why the landowner's bill of rights? Well, one reason is because we have to, right? Statute says we have to include that in the offer, which is kind of the easy answer. But the reality is, more often than not, the landowner in whose land you are taking is going to get emotional, as one could imagine, right? This is a significant event in many people's lives when a government entity comes and says, hey, I need a bit of your land, and here's some money. Thanks. The end. And they're going to wonder, hey, can I fight this? What does this look like? What should I do? Well, that's what this Bill of Rights starts to allow the landowner to understand. In essence, everything I'm telling you here is summarized very well. So really, all I should do is hand you the landowner Bill of Rights and go read it for yourself, really. But it's summarized really well in that landowner Bill of Rights, right? It talks about procedure, talks about their options as the landowner, things like that. So that's really the purpose of that is because people just don't know. They don't know what's going on. And this informs them so they can be a better landowner when it comes to these procedures, right? So that's a really important piece, not just because we have to, but because it's good for the landowner. And then ultimately that means it's good for us as the authority because it gives us that dialogue that then we're all on the same page with what a city can and cannot do and values and things like that. It just really evens the playing field in a positive way that moves things forward. And then there's a final offer letter required, and that has to be at least 30 days after the initial offer letter. So here we're starting to see some timeline, like actual statutory timeline come into play, right? Before we had however long it took to sort of figure out what you needed and okay, how much are we going to have to take and things like that. Well, now we get to a point where, okay, actually 30 days. But even before that, I need to speak on the time of the offer letter. And so here's some great practice tips, things we've run into that help. So yeah, okay, great. We need an offer letter, which means we need a bona fide offer. Great. How? Because we need a qualified appraiser to give a fair market value. Okay, great. Of what? Right? Not of, over there-ish, right? You can't appraise that bit of over there-ish land that we're probably going to need, that much for a lift station. No, we need to know how much via survey and meets and bounds. So talking timeline, now you're walking back. Well, how long does it take to get a surveyor? There's a question I've heard. Well, I don't know, a while. Depends on how much you want to pay, right? So as we walk back, maybe 30 days to get a survey done. Okay, great. But what if the surveyor goes and knocks on the door and says, hey, I need to come map out some land on your property because the city is going to take it from you. Thank goodness I'm not a surveyor. That's not a conversation I want to have, especially in Texas where people have guns, right? So, well, that landowner may be like, no, right? Well, okay. Well, now what do you do? Well, you can actually get a court order that allows the surveyor on the land. But if you know anything about courts, that's not a tomorrow thing, right? So now we're talking about filing under the occupations code, which is my least favorite code, if anybody's interested. You're not, but it's my least favorite code, and they hide so much stuff in there, but never mind. So that's in the occupations code, and so then, yeah, you can force that surveyor through a court order onto the land to conduct the survey and meets and bounds. But now we're talking, okay, setting a court date, setting a hearing, right? Going before the judge. So we're not even to the offer letter yet, right? Get what I'm saying? You know you need it. Hey, we need a lift station there tomorrow. Well, great. In about 6 months from now, we'll get you a survey. And then we'll appraise it. And then we'll send the first offer letter. And then 30 days later, we'll send the final. And then, you know what I'm saying? So again, all I'm stressing here is it's longer than you want it to be. Bottom line, it's always going to take longer than you want it to be. Other must-haves, or I guess really other really great to-haves, is a title search. Often when we receive sort of depending on the status of when we receive it, we'll go ahead and run a title search in the office. Why? Because there might be lien holders that haven't been noticed. You know, if a bank has a mortgage on it, or if there's a materialman's lien or a mechanic's lien, some other lien on the property, those have an interest in the property and need to be noticed as well. So often we'll run the title search and go, okay, hey, we need to send notice to this party and this party as well, bring them all into the suit and kind of go from there. So if you run that title search much earlier and discover, they have a couple of lien holders that we also need to notice, great. We've run into an issue with some lien holders, or not an issue, where they've said, oh yeah, we're fine, we don't care about any of this. We're like, great, fantastic, but we've statutorily noticed you, right? That's important. So those are the type of things that are good to have. And then I always like to have, personally, the city plans. Like I don't know your cities as well as you do. And we'll talk about special commissioners in a moment, and they're in the same boat. I personally like to have sort of, hey, what's the engineering plans? What's the, what are your plans when it comes to this? Just a graphical representation or a picture overview, things like that. And those are useful in the survey or in the appraisal as well. Just sort of pictures to tell the story of what the city's doing, right? Because that's important. That's important to tell the story of what the city's doing to kind of show that public purpose. But again, bottom line, this all adds to the timeline. But let's say we've done it all. We've done the appraisal, we've done the survey, we've sent the offer letter, we've sent no response, or the go pound sand response, whatever the response might be, and then we get send the final offer letter, all that, great. Now we're actually getting to what we would call some of the proceedings, right? So you have to have an open meeting, which you're all used to, right? Especially by the way, if you didn't know, the law changed. It's not 72 hours anymore. Hopefully your attorney told you that already. If you're one of my cities and I haven't told you, I'm telling you now, it's not 72 hours, it's 3 business days. What does that mean? Just post it a week ahead of time. It's just the easiest, but no, y'all have got that. So you have to have that open meeting. And obviously, depending on the situation, this can get heated, right? Again, depending on the property you're trying to acquire, you might get the landowner that comes in and gives the story of this was my great-grandmother's whatever and this and that, right? This can be a very emotional event for a lot of landowners. Some businesses, whatever, done. Personal homes, personal property, things like that, it can obviously get very emotional, right? And so that's part of these meetings, is you're going to get that sort of potential community backlash, or the strongly worded emails or whatever that might come in based off this. So just be prepared sort of mentally for that as you go through this process, that, okay, we might get some of that pushback. But that's the point of this. There's specific disclosure. When we advise people, this is like literally the language we send them in an email, say, hey, this is exactly the motion you take. That way you check all those statutory blocks. And then finally, it is a record vote, right? So a roll call vote, just to know how everyone came down on that at the meeting. So here's your part 1 and 2. That's your kind of pre-procedure, and then getting up to procedure checklist, right? Do you have the authority? Is it a public use? Do you have the appraisal? But again, that includes survey, meets and bounds, all those other things we talked about. Do you have, and chat didn't make this because I misspelled. That's bona fide offer, not bond fide or whatever it is, offer. So there you go. There's my one mistake I made. My boss, Lauren, always tells me I always have at least one mistake. So there it is. You're welcome. You've captured it. And then that includes that initial and final offer with timeline, and then the action you take. And so there's my chat. By the way, if you haven't used it, ChatGPT or whichever preferred AI model you like is great at producing just really goofy images. And so there is my city council member sitting there with their checklist on some land and I've quoted big Texas sky. So there's our beautiful big Texas sky. So that's great. They've got their checklist in hand and they're going for it. Now, obviously, again, time, right? We've gotten engineering involved. We've gotten the landowner involved. We've gotten city council involved, right? Time before we even get to this point. But once we're in the proceedings, we can finally file 14 days after the final offer letter. And the petition is going to include description of the property, statement of public use, statement of bona fide offer, spelled it right there, and negotiations. So again, this is, a lot of times this is the point where our office will get it. Hey, here's the resolution from city council. We passed it. Here's the offer letter we sent. Go file with the court. Right, so this is often the time where our office will take it if we haven't been involved from the very beginning. And then what do? We typically run a title search, again, just to make sure that all those parties that we're going to notice in the court proceedings are properly noticed. And then we go ahead and file with the court. And what's interesting here is this is really where a timeline sort of starts. Well, if you have noticed by now, it's sort of timelines of timelines, right? We have nested timelines within nested timelines. But the next timeline we deal with is the special commissioners. So what are special commissioners and what is the special commissioners hearing? Well, by statute, they're appointed within 30 days after filing, okay? And if a couple people chuckled, it's because they know that 30 days, great. They may be appointed, or as I mentioned, or 45, or 60, or whenever the court gets around to it. Right, so that could take a while. We've had to bother a couple courts to be like, hey, could you sign this for us so we can get this going? And even once they've signed, now we have the herding of cats, right? How do we get all these people in one room at one time? 3 disinterested property owners who are disinterested because they don't own the property, but they might also just not be interested, right? So we got to get them involved and get them in the right room. And then we have city staff, appraisers, council, if opposing counsel is going to show up, opposing counsel, their landowner, things, right? All these people in one room to finally have a discussion about, and I say discussion because I'll mention in the morning there are really no rules whatsoever with these commissioners' hearings on what the actual final value should be. So the commissioners' hearings, literally the Wild West. Lauren mentioned it was a meeting I wasn't able to go, a commissioners' meeting I wasn't able to go to. Literally one of the special commissioners told the opposing counsel, sit down, cowboy. So literally the Wild West. So I made Chat give them all cowboy hats, right? Well, almost all of them. I don't know. Chat does what Chat does, right? So you can see this is kind of what it might look like. You have 3 disinterested property owners, right? These are your special commissioners. You got lawyers on either side. You got the landowner on one side. You got the engineer and or the city planner or the project manager, whatever that might be, on the other side, and just testifying, in essence, to what the value of this land is, right? Based on your appraisal, based on the project that's going forward, explaining like that. What I often advise having, yes, the appraiser's good, there's images in there, but these commissioners don't necessarily know your city, right? They don't know your project. They don't know the why, right? We talked about the why really early on behind why you're taking this property. Why do you need it, right? Is there no other options? Where else could you do this? These are all questions that I've heard come up, right? So having that city official there, whether it's a planner or the engineer, someone to just sort of talk through, hey, here's the plan, here's where we are in our city, this is what this corridor looks like, et cetera, is a really, really good thing to have. At the end of this, you get usually, or you get an award. More often than not, it seems to be objected to, right? But here we go, and I know I'm almost out of time, or I am out of time. So finally, you get an award. It's for $10,000. Great. You deposit that money in the registry of the court. Is it ours yet? Yeah, kind of. right? But you can proceed. This is the point where you want to get to where the project can continue. However, as I mentioned, please double check with your attorney before you break ground. Let's just make really, really sure that you're good to go. Because more than likely, the Special Commissioner's Award is going to get objected to, right? And I love statutory language. If y'all don't, look, I guess I'm a nerd, but I love statutory language like this. On or before the first Monday following the 20th day. Right, that's fair. Whoever, someone got a raise for writing that, right? Like, someone's sitting there like, well, 10 days is so ambiguous. Why would we talk about that? So 20 days, yeah, but past a Monday because we don't work over the weekend. And then we get, right, like, so great. There it is. That's great. I reach out to Callista at our office and she puts it on the calendar. That's how I know when it comes up. And then the calendar invite pops up and I go, oh no, it's today. So that's how that gets done. But ultimately, this could result in a trial, right? And trial literally could take years to get to. But that's why the possession I talked about is so important. We actually have a case where the project is done and we're still waiting on the trial date. Or did we, that may have been resolved. But either way, it got to that point where when I joined the office, 3 years ago, this was a couple years down the road, and the project's done. The road's built, but we're still in this procedure of trial. So just note that. I underline mediation there because a lot of these the court will force mediation. It'll end up in mediation, and that's sort of where a lot of things can end up being settled out instead of trying to go to trial. So a couple key points to remember. Hang on, I think this is my last slide. Yeah. So congratulations, it's yours now. Look, everyone's happy because this is how it always ends. Everybody shakes hands and city council gets to put shovels in the ground and things like that. But ultimately, just remember, it's longer than you think, and it's probably going to end up costing more than you want it to. So thank you for your time. Questions later.